Welcome to the Public Opinion Court, where the truth ain't reality, but opinions are. Listen, domestic violence cases are never easy to report on, and today is no different. In Arlington, around 10 a.m., the mother of the credit champ, who has a massive following on social media and is a content creator revolving around his business of helping individuals repair their credit. He was in the barbershop, as I heard, is seldomly throughout the week. He was in a barbershop today getting, I guess, his weekly lineup when his baby mother, who we still have not identified, walked into the suite. It was a salon suite, walked into the suite and unalived him. Then this individual took her own life. We do not know the surrounding facts. We do not know the why. We may never know the why. Everybody is going to assume. Allegedly, they were not together. Allegedly, it may stem from a posting that he recently made as less than 48 hours ago. But to give you a little more insight into what happened, let's bring it to you.
In Arlington, where some people are trying to come to grips with what they witnessed at a salon. Police are calling it a murder-suicide. And Tanya Iser just heard from some of the witnesses who feared for their lives.
Active shooter response at the spa.
The call came in just after 10:15 Friday morning to a strip shopping center on South Cooper Street, normally a quiet spot in South Arlington.
Somebody came in and shot a client.
Mario Ibarra works there. Inside one of the suites, he and others say the man who died was in the chair getting a haircut when the gunfire started.
I heard gunshots on the other side of the building.
Another witness, too shaken to go on camera, told us the victim was a regular here. He came to the barbershop several times a week. He says the shooter fired a burst of shots, then began telling everyone to get out and tried to get into several stalls. He says he locked himself in with a customer and said to himself, "Lord, just let me get out of here." A bystander recorded the moment police arrived on scene and entered the building. Officers say the woman had tried to leave, but when she saw police, she ran back inside and shot herself. The man died here at the scene.
We were all scared. We didn't know what to think of. We were just scared. I have no idea what to think, really. But we were just all hiding and wanting it to be over.
The shooter died later at the hospital, both just 37 years old. 2 lives, gone in seconds. Police say the two once had a romantic relationship, and tonight they're still working to understand why it ended in tragedy. In Arlington, I'm Tanya Iser.
Now, just to bring it back to the focal point of this being a domestic violence altercation that ended in the unaliving of 2 individuals who also have a child together. So they leave her back, who also have a child together, which means they leave their child here parentless. Now, I did a little research. I went digging and I found the credit champs. Now, I went on and did my own little digging, and I went to the Credit Champs page, and let's go over, some of the things that I was able to see. Now, I did go to the Credit Champs page, which you can go and follow, and as you can see, he literally just posted over 19 hours ago some of his final moments. Not expecting to be unalived today. I don't know if they had any beat, but I went and checked his page, and I can only assume that it may have something to do with that post from last night or yesterday where he had bought a Birkin for somebody and that Birkin may not have been for her, but I don't know. That's just an assumption. But usually when individuals have money, influence, and they're beefing with their significant other or the, mother of their child, i.e. ex, sometimes it's best to just walk away and not engage or entertain. So I don't know where her mental state was, but let's take a look.
Okay, I'm here to tell the story of Michelle and Todd to clear the false narratives. He did not give her HIV. He was not cheating on her at the time of the murder-suicide. In fact, they haven't even been together in over a year. Yeah, Michelle came from nothing. She built herself up as a veteran, as a successful business owner. Her knowledge, the things that she knew in order to get money to take care of her kids as a single mother. When she met Todd, Todd was living downtown Dallas under a CPN number. He did not know how to do credit repair. She taught him how to do that, and they built this business, Credit Champs, together. Whenever they broke up, because I see he's been sending his clients the video when she pulled the gun on him. She wanted him out of her house, and he would not leave. There's an active restraining order right now against him. Terroristic threat against her and her son. He threatened to kill them both. Okay? Todd reversed all of Michelle's mortgage payments up to I think 18 months, probably more. to the point she was about to lose her home. How he did this is because they have a joint bank account. He removed her off of the bank. I don't even know how he could have even did this, but he removed her name off the bank because she had no access. He created a new email for everything to go to, not the email that they had. Michelle went to Vegas one weekend, and she came back, and all her money was gone. Now, could you imagine having $250,000 or even $500,000 in your bank account, and now it's zero? You can't pay your mortgage, you can't take care of your kids. He's threatening you. He's not giving you nothing for your kid, okay? Michelle had several cases against this man, okay? Me, as well, had a lawsuit that I just won and got paid off a day before the murder-suicide. Michelle was suing him for a lot. He was taunting her by still promoting this company, still making money off this company that they built, not giving her access to any of the money. He also wrapped a Cypher truck, was riding past her house. She could see it on her Ring camera. He was taunting her. She was so full of debt. She was about to lose her home. The air went out in her Tesla. It was just a lot of stuff going on, and she had $0 to deal with her situation. She reached out to family. She reached out to people to help her. That man stole her whole life, and he flaunted it in her face. Todd also took her $10,000 settlement payment that she got from the military. When he got access to her phone, he drained her personal account, locked her out of her business accounts, wouldn't help her with her son. So all of this stuff, I just want to clear the false narrative. He is not who you think he was. And I'm not.
Nigga.
You don't know what goes on behind closed doors and what people are dealing with. I would just say just pray for the family, because 2 individuals were unalived and they have a child that has been left behind with no parents. I pray that they had their affairs in order. And it's always another way to escape situations like this. You don't always have to unalive anyone. I'm in prayer for the family. Y'all be in prayer for the families, and be in prayer for their souls that they make it to heaven. The breakdown that I have, it's not being circulated in the masses because there's been a lot of news that has been making its waves. We're talking about the infamous "They Not Like Us" beef. And I'm not talking about the beef that you go and you consume. I'm talking about the beef that only the court of law can handle. So let's get into it. So you all know that Drake sued his record label, UMG, after the infamous, legendary beef that himself and Kendrick Lamar had last summer. Literally, as we're speaking right now, the beef was going on, and it kept going, and it kept going, and it kept going, and it kept going. But I reported on this last year, and a lot of people was like, you crazy. This is just a rap beef. I said, no. He said something that is very damaging, and you cannot say that. It is not rap art. It is not lyrics. It is accusing somebody of being a child predator. And that will get you landed in the court of law. So I just wanted to refresh our memory a little bit, so that, because people be like, you know what, they be having amnesia about the things that I report on. Sex crime that carries defamation. You cannot just be going out here saying anything about people. Anything that could defame their character, affect their reputation. This is a clear example of defamation. And the reason why, when I reported on the original filing, they was like, oh, Drake, he just nasty, he's so bitter. No, he's standing on business because, one, you cannot make allegations that somebody is a pedophile, which is a child sex crime that carries hefty sentences, as well as you have to register as a sex offender for the rest of your life. You can't be around children. It's a massive allegation to make when you know it's not true, or you have no actual knowledge that it's true. And actual knowledge is a criminal case. Has a criminal case ever been filed? No. Another has a civil suit where the party suing him for these kind of claims been filed and this person has prevailed. A defense to defamation is the truth. My question to y'all, because I'm going to ask y'all a question. There is no criminal complaint that has ever been filed by Drake, and there is no civil complaint that no one has ever prevailed out of these allegations. Y'all think UMG going to be able to prove those allegations in that song are true? I called it last year, y'all. I called it. I said that when this happened, immediately I said that Kendrick was going to be looking at a possible lawsuit because of this. Luckily, Drake went after the corporation, i.e. his label, instead of Kendrick. Because yes, it is a rap beef. It's a rap beef, but when you have big wigs that are pushing the narrative and the engine and funding and trying to end you because you got contract negotiations coming up and they don't want to pay you. They want to drive your value down instead of up. So they elevate a beef, i.e. payola, which is a federal offense. Now you possibly got a RICO coming to UMG if the feds want to pick it up. Let's get into what happened this week. Now, what a lot of you don't know is that Drake and not Drake and Kendrick, the beef is just still beefing, but Drake and UMG, his record label, were in court because UMG filed a motion to dismiss. And for those who are new to this platform, are new to certain legal terminology, a motion to dismiss is when an opposing party that a lawsuit is filed against file a motion to dismiss because they're saying is baseless or the merits are not do not accompany the type of lawsuit that was filed. However, it's like a last ditch effort when you can't get it a motion for summary judgment or motion for dismissal. That's a last ditch effort to try to make it go away without having to go through the full extent of a trial. So they were in court this week on a motion to dismiss. Now, let me give you a little background about this issue, this beef, this legendary summer 2024 beef. So we all know what defamation is. If you don't, defamation is when you say something that you know or should know that is not true, that could damage someone's reputation. You say it in public with the intent to harm someone's reputation. That's just a hey homegirl kind of breakdown of what defamation is to try to, bring it on down to reality. Drake last year in his defamation lawsuit, he says that UMG, his record label, approved, published, and launched a campaign around the song presenting these false accusations as factual. Negligence and harassment. He claims UMG ignored notifications about threats, his son's safety concerns, and episodes of violence tied to the track. RICO and pay-to-play allegations. RICO! It's raining RICOs. Drake previously claimed UMG conspired with Spotify to artificially boost Lamar's track and to promote it aggressively, implicating RICO in deceptive business practices. I knew this was coming. I said this. I said when I read the actual petition, it was giving RICO. We all know pay to play is a federal crime, but everybody in that industry do it. Everybody, they're getting paid. And what Drake is doing is exposing a system that was so comfortable in the pay to play to where they went after one of their very own, and their very own got it and shot back. That's why I'm not mad at Drake. I actually appreciate this because it's going to change and be in law books for decades to come, because this has never happened. It's never happened to this magnitude. We know the last time somebody went at the network, i.e. Bill Cosby, what came from it? Okay. Let's go over the timeline because the timeline matters. We know the beef took place last summer, 2024. Drake Setback, strategized, got his in order. He wasn't playing. He got it in order. And what that means is when you strategize in a crisis, you have to be so quiet that even your enemy wants to do a welfare check on you. So what your enemy will do is lay out a smoke signal to see if you're going to take the bait. Drake didn't take the bait. Drake and his crisis management, i.e. legal team, got to working. They got to collecting. They got to getting access and meeting with people who admitted to being paid to play not like us. You are never supposed to let your enemy see what you're doing. So on November 24th of 2025, when he dropped the petition for that lawsuit, the world went bananas. Oh, Drake is suing. Oh my God, that is so weak. That is so sassy. Oh my God, he is suing. He lost the rap battle. Now he want to take it to court. He want to win. No. What he did was caught his record label with their hands in a cookie jar in broad daylight. They left their prints and they left some crumbs. So all he did was collected it. He went and scooped it up and said, okay, you clocked it. I'm gonna give you that, but watch how I clock it. So he filed the lawsuit for streaming manipulation. He filed under, of course, RICO against UMG and Spotify. Of course, they came out with denial. They don't expect, this big corporation do not expect people to nuck and buck, and Drake did. January 15, 2025, a formal defamation of lawsuit was filed in New York's federal court. On March 17th, 2025, UMG moves to dismiss, calling the claims utterly without merit. March 20th, court denies UMG's bid to stay discovery, and Drake proceeds. So what they essentially saying is UMG, even with this motion to dismiss in the system, waiting a hearing date, they filed to stay the discovery until the motion to dismiss had been heard and there was a ruling. The judge was like, Discovery is a continuing cycle. The wheel keeps turning on discovery. The wheel does not stop on discovery. It keeps going. So the judge basically said, we're going to keep with discovery. Keep it going. What are we stopping for? So on April the 18th, Drake amended his suit to include the Super Bowl performance. I said that was going to happen. After seeing his performance and seeing that he used that word still, he's allowed to amend to add even more evidence to support his claims. They not like us. I know. So let's talk about this motion to dismiss hearing. What happened? What do y'all need to know? What I basically did was pull excerpts of the communications with the judge and the parties that were involved. It's short, sweet, to the point. So what they filed under in order to file a motion to dismiss, a Rule 12 motion. In that motion, the judge asked Drake's lawyer, under Rule 12, the court only considers whether a reasonable listener could think lyrics were stating facts, not whether those facts are true. Oh, that's what I thought too. That's what I had thought. That's what I had said to y'all, but some people didn't want to pick up what I was putting down. So I hope you're picking up what I'm putting down right now. So let me read that again. The court only considers whether a reasonable listener could think lyrics were stating facts, not whether those facts were true. So essentially what they're saying is, as a listener, I do not have to concern myself with the validity. But if I believe in you as an artist and I love you as an artist, even if I don't, I can believe that you are stating facts with no proof in eyesight. So that's essentially what he's arguing. The use of the lyrics and cultural reach. Drake's lawyer says UMG turned the diss track into a cultural phenomenon. We all know they had over 9 billion streams. And even being played at a bar mitzvah. Y'all, why he brought that bar mitzvah in, I don't know. But that was kind of kiki. It was funny. Because why was they playing it at a bar mitzvah? I don't know. Probably because we not like them, because we don't throw bar mitzvahs. I get it. So the judge joked Like I just said, he was like, an interesting bar mitzvah that would play that song. Yeah, it's very interesting. I told y'all. The judge took judicial notice of the lyrics themselves. The lyrics are what they are. So what it means to take judicial notice, it means that this particular statement, evidence, date, time, is purported to be that. So nobody has a dispute on what the disputed evidence is. So the judge takes judicial notice. The judge brings up the AI voice for Tupac in a rap battle context. The judge said Tupac's voice was used by Drake on a diss track. Drake's lawyer countered, it's not relevant to the defamation claim and shouldn't be conflated with this case. Of course it's not. Of course you're going to say that. So what the judge stated was, he noted that Kendrick Lamar's performance included the track. So we go to the Super Bowl. Drake's lawyer pointed out UMG knowingly republished and promoted the contents during the Super Bowl, leading to threats and attacks at Drake's home. So what they're essentially saying, this picture that I have, the one that was used for Kendrick's artwork, caused an uproar to where there was violence that showed up on Drake's doorstep, which is true. One of his security was shot. People were coming to his home. Their life was in danger. That adds and adds and adds and adds. So he emphasized that the album art depicted Drake's home with sex offender tags, a clear insinuation of criminal behavior. You cannot do that. That's also considered doxing. You cannot do that. You cannot do that. Defamation, the defamation debate. Let's talk about it. So UMG and the judge questioned, should rap lyrics be seen in the context of artistic expression and battle culture? Yeah, to a certain extent, that is the essence of hip hop and rap battles and lyrics and going back and forth. Like one person, coming and you coming back with another punchline and y'all going at it. However, it's different when you accuse someone of a pedophilia crime in order for your record label now to take it, republish, pay behind the scenes to get this record blasted so high that you get promoted to being the artist for the Super Bowl. You picking up what I'm putting down? So they had to look at it like it's a question. However, Drake's lawyer was right. This is not a question of fact for the judge to determine during a hearing. It's subjective and it's for the trier of the facts. What would a jury of peers believe is reasonable? That's who should have that kind of disposition, not the court. Because, like I said, it was during the motion phase. That's why I said during the hearing, this is not for the hearing. This is for the trier of fact, which are juries. So ultimately, the judge denied UMG's motion, like I thought, to stay discovery. That happened. What he essentially did, also in the hearing for the motion to dismiss, he said Drake's team can continue seeking internal UMG documents, including communications related to the Super Bowl campaign and Lamar's record deal. That's going to be big. So what's next? Drake has been clear. Drake took a W today. UMG took not today, but this week, UMG took a big L. Because what they were fighting so hard for, the judge actually cleared a major hurdle along with dismissing the motion to dismiss, and said both sides now will have access to documents that could reveal UMG's internal reasoning, marketing strategies, and awareness of potential harm from the Not Like Us. That is big. That is huge. That is handing a big corporation the biggest L in the music industry that has ever been seen and probably will ever be seen on this level. Like I said, what Drake and his team did, they set back. They got quiet and they strategized. They put the pieces together. They said, don't say nothing. We got this. Because they do. And like I said the last time when this was going to happen, and y'all was like, this is bigger than rap. This is about a corporation that uses its power and influence to grow a criminal connotation of a crime against their own artists in order to drive their value down so that they can come to the table with an L from this rap battle and say, oh no, we don't need to pay you that because your value has went down. They were banking on that, but they wasn't banking on that. Drake was sitting back. What did I miss, Drake? Oh, you ain't missed that much, Drake. All you did was, come back with a vengeance. So be careful when you come with a vengeance and not facts. Because everything is discoverable. Everything can be found. And that's how you lose. You never win when you play dirty. You never win. So the next step, of course, discovery is an ongoing phase. I can probably anticipate, because Drake settled with iHeart. I can anticipate that everything, their worst nightmare, is about to be revealed at the hands of the light-skinned Drake from Canada. But listen, y'all know I'm going to keep y'all up on the latest and the greatest of things, and I keep it fair and real over here. We don't tear individuals down. We stick to the facts so that you can be educated, and I can do what I love to do, which is break down the law. Because at the end of the day, they not like us. And then I'm going to ask them, what did I miss? Because I don't miss nothing. I don't miss nothing when it comes to the public opinion court, where the truth ain't reality, but opinions. They not like us. 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 Or is it, what did I miss? Because when I pop out, I'll be like, oh, what did I miss? Nothing. Oh, let me go back in my cocoon. But that's the breakdown that I have for y'all for the Drake and Kendrick UMG court battle, the legendary court battle, the court battle that is going to keep on giving and giving and giving and giving until we get a court date. And I'll make sure I'm there for that court date. I'm going to be in that courtroom because it's going to trial. It is going to trial. We are here to report on the viral McDonald's stabbing. And I'm pretty sure no one has been on a rock to have seen the viral video of the McDonald's employee who went live in her car to talk about her gripes with her then manager and how her manager had been playing with her money, had been playing with the atmosphere, was negative, always causing issues that managers should not do. So she went live and she, talked about her experience. And I think so many people could relate, because when managers get beside themselves and believe that they're bigger than a program, they start to trickle that energy down to their employees. And truth be told, listen, you got to be careful how you treat people. So what I'm doing right now is I'm just breaking down the bond hearing that was held today, as well as the warrant that was issued. So being a former municipal court judge, the one thing that I was in charge of was making sure when officer came in for arrest warrants or search warrants that I was able to do my checks and balances to see if they should be allowed to be issued the warrant that they were asking for. So I was the first line of review. And of course, there's more reviews to come. However, in this particular matter, what you're going to see is an officer, detective that is in charge of the investigation of this incident. He's going to go before the magistrate and ask the magistrate to issue an arrest warrant and a search warrant. What that does is give them legal authority to go and search particular areas that's lawful, as well as make a lawful arrest. Now, because she was already arrested, that doesn't stop the fact that they still have to follow the formalities of it all. And I'm going to tell you like this, that judge issued a $25 million bond. Is you cool, Judge? That is so unconstitutional. So freaking unconstitutional on so many levels. And it's definitely giving race related. That judge actually needs to be reviewed. $25 million on. Is you cool, Judge? Or do you need to go back and learn something about reasonable bonds? She worked at McDonald's, for goodness sake. And you issue a $25 million bond? Listen, I can't make this up. I cannot make this up. But let's get into what I have for you all.
All right. Previous court of non-session. I will Captain Davis presiding.
You may be seated. Good afternoon, everyone. Detective Showers, please approach for the swear-to. Please raise your right hand. Do you swear that the information being provided is true and accurate to the best of your information, knowledge, and belief, subject to penalties of perjury?
I do.
Put your hand down. With regard to the defendant, Afani Muhammad, please set forth the factual basis for the warrant request.
Yes, Your Honor. On 7/10/25, McDonald's employee Afeni Muhammad stabbed McDonald's manager Jennifer Harris multiple times with a kitchen knife at the McDonald's restaurant at 179219 Mile. Harris was not armed at the time and died of her injuries. Prior to the stabbing, Muhammad was sent home by Harris for not performing her work duties and told Harris, "I'll be back." Muhammad was arrested on scene and the knife was recovered. Muhammad admitted that she intended to kill Harris and stated that after she was sent home, she drove to a nearby park, decided to come back and stab Harris with a knife that she had inside of her vehicle. When Muhammad returned to stab Harris, she entered the back entrance with a hood mask over her face in an attempt to conceal her identity and attempted to flee the scene after the stabbing, but was stopped by an armed customer.
And the requested charges are murder in the first degree, count 2, dangerous weapon carrying with unlawful intent, and there's a habitual second notice offense. Is that correct?
That is correct, Your Honor.
The warrant is being signed, and we can proceed to arraignment.
Thank you, Your Honor.
Calling file number.
So what is about to happen now? The judge is going to arraign the accused, who is now going to be identified as the defendant, take this up before her. And this doesn't mean guilt or innocence. It doesn't violate her constitutional rights. She still has the ability to proceed, and her due process rights are going to be afforded to her.
Number 25354, People versus Afani Badu Muhammad. Counsel appearances for the record, please.
Good afternoon, Your Honor. Sean Hayes on behalf of the people.
Thank you very much, Your Honor. Please, this honorable court, man, from Conferring on behalf of Mrs. Muhammad, who does appear via Zoom.
Your name, please, ma'am.
Afeni Muhammad.
Very good. You're here today for arraignment on the charges of murder in the first degree, premeditated, count 2, carrying a weapon with unlawful intent, and a habitual second notice. Mr. Licata, how does your client wish to proceed?
Thank you very much, Your Honor. At this time, my client is asking the court to enter a not guilty plea, and this matter set for a probable cause conference in the preliminary exam. I have advised my client of her rights, as well as the charges against her and the potential penalties, and we are ready to proceed on those grounds.
Very good. Ma'am, do you understand the nature of the charges against you to your satisfaction after talking to your attorney?
Yes.
Very good. I will go ahead and enter a not guilty plea on your behalf. Are you requesting a court-appointed attorney?
Yes.
I will appoint an attorney to represent you. We'll set this matter for a probable cause conference on July 23rd, 2025 at 1 p.m. The preliminary examination will be on July 30th, 2025 at 1 p.m. Esteban, Mr. Licata.
Thank you very much, Your Honor. Just briefly, my client is 26 years old, does live in the great city of East Point. Your Honor, my client is a high school graduate. In fact, is actually was taking some online classes for college for a physical therapy degree. Your Honor, there are some disturbing facts in this particular matter, but there are facts that haven't been brought out yet, and my client is extremely anxious to have those facts brought to light during the pendency of this case. She was in an extremely abusive relationship that was not only mental but physical, that involved alcohol issues, which is where the habitual second stems from, and her prior record. Your Honor, my client is a helpful person. She's a giving person. She's actually is credited with saving a life because of a 60-year-old who had skin cancer that she may go to the doctor to find out that that's exactly what it was, and that person is doing extremely well right now. I understand the facts that have been laid out today in the warrant, but at this time, Your Honor, we are asking the court to consider a bond in this manner that is appropriate, that my client can meet so that she can meet with her attorneys and prepare her for defense in this matter. Thank you.
Thank you. On behalf of the people?
Yes, thank you, Your Honor.
So I would tell you, her appointed defense attorney for the purposes of bond, I don't believe he may be appointed to handle the duration of the case when she's determined to be indigent. However, they are only limited in the information that they can retrieve in order to argue for a reasonable bond. So he did exactly what he could do, bringing up some mitigating factors that are good against the aggravating factors that is the unaliving. So don't give him too much smoke if you think, oh, he ain't do enough. No, he did just enough. And now we're going to hear from the state. And you know, the state is always going to add sauce where sauce is not even requested.
Pursuant to court rule, the court is well within its authority to grant no bond involving any case involving murder. In this case, we are requesting no bond for this defendant. Also provided within the court rules are certain factors for this court to consider when determining whether to grant any bond at all, and in this case, we are requesting no bond as I indicate. First of all, the court can consider whether or not this defendant is a threat to the community. She entered a public building with other individuals, other employees that were present. She produced a weapon that was a knife longer than 3 inches, and she stabbed the victim multiple times, up to possibly as many as 15 times, eventually causing her death. There were other employees that were present at the time, some of which attempted to help the victim after the stabbing occurred.
Hold on. I had to stop this because this is just ridiculous. This is what I have an issue with. This prosecutor does not know how many times this victim was stabbed. She has not seen a video. She has not seen an autopsy report. She has not seen anything to allude or assume that it's more than 15 times. That be my problem with these Caucasian prosecutors, be adding facts that don't align with the truth. Like, girl, why would you even say up to 15 times when you simply don't know that? Like, is you cool? Girl, you ain't even seen an autopsy report, let alone you ain't go view the body. The body is still probably hot. You ain't went down there to see. Don't do that. That is literally what I be talking about with these Caucasian prosecutors, adding facts that don't fit the reality. Do better.
That alone is enough to show that there's a threat to the community. She then ran from the building to her vehicle, presumably with the intent to flee from the scene. She was stopped by a helpful bystander. You're also able to consider the likelihood of conviction in this case, given the facts as laid out by Detective Showers and the information that the prosecutors have reviewed in order to charge this defendant. There is a very high likelihood of conviction. And then finally, the defendant does have a prior instance of at least one that I'm aware that involved a stabbing, similar obviously to the stabbing that occurred in this case involving a knife. So given all of those factors, and given the fact that this court does have authority to give no bond to defendants charged with murder, I am asking at this time for no bond in this case.
Thank you, counsel. The court has reviewed the charges and the circumstances surrounding this case. The defendant is facing various serious charges, including murder in the first degree, which is one of the most serious criminal offenses in our state, carrying penalties up to life without parole. Additionally, carrying a dangerous weapon with unlawful intent further underscores defendant's potential threat to public safety. Defendant has a prior criminal record out of Virginia for malicious wounding. It was actually felony malicious wounding that was reduced to unlawful bodily injury concerning a stabbing, and that is what gives rise to the habitual second. And in determining bond, the court must look to the factors outlined in Michigan Court Rule 6.106. Number one, the seriousness of the offense and the danger posed to the community. The charges here involved a violent crime with a weapon, indicating a substantial risk to the public. The court finds there is a significant threat to public safety, and therefore the bond must reflect that risk. Number two, the weight of the evidence against the defendant. While the evidence is not fully before us and the defendant is cloaked with the presumption of innocence, the nature of the charges along with the prior criminal history suggests that there's substantial evidence against the defendant. Defendant's criminal history: the defendant has a violent criminal past. The history supports the court's concern that the defendant may engage in further violent conduct if she is released. The defendant's ties to the community: while the defendant is relatively young at 26 years of age, there's no indication that she has any significant stabilizing ties to the community that would ensure her return for court appearances. Without these ties, the court is concerned about the likelihood of flight. Number five, defendant's risk of fleeing or failing to appear. Due to the severity of the charges and the habitual offender status, it makes the defendant a high risk for flight. The court finds that this factor weighs heavily in favor of a high bond amount. Substance abuse or mental treatment: although there are no reports at this time suggesting that the defendant suffers from mental health or substance abuse issues that would mitigate the risks posed by defendant's release, the court is, after considering all of these factors, going to be setting bond at $25 million, cash surety only, with conditions. If the defendant is able to...
This is ridiculous. Listen. I'm going to let this finish because I got time.
Meet those conditions, she must be on a GPS steel cuff tether. She is not to leave the state of Michigan. She is to report her address within 24 hours of, she must report any change of address within. Let's
talk about it, because what that judge did was so unconstitutional on so many levels. Thank God that it's just a magistrate judge and not the actual judge that is going to handle the case on down the line. So she will get another bite at the apple in order to get this to be reduced to an actual reasonable bond. So what we just saw was a judge decide that she was going to use aggravating factors of a prior reduced offense that may have mitigating factors that she simply don't give a fuck about. Yes, it's unfortunate that this individual, from the allegations, is alleged that she went to work to make up time that she missed from being removed from previous days by this particular manager. She went in, turned around, got frustrated, went to a park, allegedly decided that she was going to go back in and unalive her manager. Now the mask over her face, that is very crazy. Yeah, I can see the premeditation and the intent behind it. And the actual offense itself, yes, it is heavy. It is heavy. It's heavy on the intent. And less on you had a lawful reason. So nothing about that was lawful. However, the court did not provide a sufficient amount of reasoning as to her being a flight risk outside of her going to her car. You don't know what you want her to say. How does that make sense? She did not try to leave after she was being held by the patron. Then you want to say that she had this prior violent offense. It does not rise to the level of felony. It was reduced. That is not significant enough criminal history to rise to a $25 million bond. The facts, yes, are the facts. The evidence have not been concluded. And that's why I have a problem with that prosecutor saying she believes that she was stabbed over 15 times when the evidence is not even fresh off of this individual's body. Be for real. 25 million. They didn't give Epstein a $25 million bond. They didn't give Weinstein a $25 million bond. They didn't give Luigi a $25 million bond. They didn't give the Oklahoma City Bombers a $25 million bond. Hell, they didn't even give OJ a $25 million bond. They didn't give Rittenhouse a $25 million bond. They didn't listen. The list can go on and on and on and on. They didn't give Derek Chauvin a $25 million bond. They don't give officers who intentionally kill Black and brown individuals $25 million bonds. So be fucking for real, magistrate judge. What in the delusion are you living? Are you living under a freaking rock to understand what your job and your duty calls you to do? Not to impose your personal views. And I can see, and I assume that she imposed her personal views, and that is not okay. I have a big problem with that. A big effing problem. But like I said, it's unfortunate that a life was lost. It's unfortunate that this individual could not walk away. This individual could not de-escalate herself. This individual went back, planned, and executed her plan. Now we have an individual who is unalived, and her four children are without a mother. None of this is okay. Justice will prevail. However, that does not mean the individuals who are in charge of making sure that justice prevails in a fair, just, and constitutional way can interrupt what their duty requires them to do. So I wanted to report on this. I'm literally hot because it's about being fair. It's about not imposing your personal views. It's about not going in with the glass half full. It's supposed to be empty. Hot out the press, breaking news, because it's innocent until proven guilty. Punitive damages that were awarded to T.I. and Tiny on the behalf of the OMG girls who brought a trademark infringement lawsuit in federal court against MGA Entertainment for their LOL dolls that infringed on their rights. Now, we were all surprised that they got $53 million in punitive damages. Punitive damages are usually to deter bad actors from intentionally or maliciously or committing fraud against individuals that have caused them damages. So what a jury did in this particular case, they said, hey, this is punitive. We are awarding $53 million. And everybody was like, what? So what MGA did, which is what they always do, is filed an appeal. on the behalf of the damages. And I'm going to tell you what the court stated. In a ruling on Tuesday, July 8th, the U.S. District Court Judge Mr. James Selma, determined that 53.6 million granted from punitive damages were unsupported by evidence. Instead, he found that the maximum punitive damage award was substantial by the proof of $1. Don't play in our face, Judge, because them people, the jury, you are invading on the jury's decision. Don't piss us off by disrespecting the jury. What he said in assessing the evidence of MGA's willful or intent, the court finds that the amount reflects the fair value of punitive award for MGA's conduct, that $1, don't play with us. He also stated that the ruling states, adding that if the pair isn't willing to take the remaining 17.9 million left in addition to $1, their other option is a new trial. Now, in the original lawsuit, TI 44 and Tiny 49 claimed the company violated intellectual property rights of their music group, the OMG Girls. When we took on MGA, they stated we stood up for the OMG Girls, but also for something bigger. We stood up for every creative who wants to protect their vision and brand from unfair use without recognition and compensation, because they literally could have licensed it. It was that simple, clock it. But they like to steal, and they don't think people going to nuck if you buck, and they say, nuck, buck, and we got you. So the OMG Girls lawsuit showed just how hard it is for creatives, especially Black artists and young entrepreneurs, to protect their intellectual property from billion-dollar corporations. Now, per the documents, Judge Selena issued a new ruling after MGA argued it did not act willfully and the award was excessive. Ultimately, the court found that while there is evidence that at least one designer was aware of the OMG Girls' existence in December 2019, it fails to show that there was a deliberate intent to copy their trade dress upon learning of their identity. Now, I find that very hard to believe, and let me tell you why. They could have done their checks and balances by going to the USPTO and doing a proper search, a proper vetting. They are a billion-dollar corporation. They have the research, they have the funds, they have the ability to research, they have the people on staff that can go in and do the checks and balances to prevent this from happening, but they didn't. And I believe with that one bad apple will spoil the rest of the bad apples, and that one bad apple spoiled the rest of the bad apples, and the jury saw through that, and the jury said, yep, if there's one, there's many. So we're going to award punitive because they should have known that this was in existence to the masses of where they went out and they copy and pasted. Now we've been a copy and paste out of their bank account, 53 million in punitives, and over 17 in actual damages. So what the Harrises is going to do, they say, you know what? We ain't never scared because we from the A. We ain't never scared. So they decided, okay, we can go back and prove this punitive damages since, Judge, you want to play in the jury's face and the jury awarded us this, not you. And I don't know who you got paying you and paying for your campaign and try to, go back door and do all of this. But nuck if you bug, because we're going to bug back, and we have bugged back and we have won before. So if anything, this has taught the individuals who need to protect their brand, because we are a business of protecting brands, intellectual property, and have had to nuck if you buck on some individuals and it got them taken down. Make sure you are protecting your intellectual property. Do not be afraid to go after these big wigs, because the best defense to protecting your intellectual property is to be on offense. Always be on ready with a strategy and a plan. So shout out to T.I. and Tiny for standing on business behind the OMG Girls. And I have no doubt that they're going to prevail in those punitive damages. If not 53 million, they're going to be in the millies. Now, y'all know at the Public Opinion Court, we know the truth ain't reality, but opinions are. And just like all the time, y'all, make sure you are liking and subscribing. Make sure you are following my social media pages, staying engaged. I love doing this, and I'm growing my community. I need to get to 500 subscribers. So what you can do for me is send this to your friend, because I need to monetize this channel. And I know y'all want me to monetize because y'all love me and I love you. So if you can help me by sharing, telling people to subscribe, I would really, really appreciate it, because I keep it real over here, and y'all love real. I love real. Other than my hair, that's my business though. But until next time, y'all have an amazing